Hey there, and welcome to Thursdays on the Stoop. I'm Julian Schendelman, one of Blue Stoop's two co-directors, and we are here today with Gabrielle Sellei, an entertainment lawyer who founded Sellei Law in 2015 after practicing employment, business, and entertainment law in the Philadelphia area for 20 years. We're going to get started, and I'll let Gabrielle take it from here.
All right. Well, thank you, Julian, and thank you guys, Blue Stoop, for having me. One of the, well, as Julian just mentioned, I am an entertainment lawyer, which means I work with a lot of creative people. Writers are my favorite of every kind of client because I think we all share an understanding of just how critical the exact right word can be in anywhere, which we're going to talk about in a little bit more detail. But yeah, so I don't want to take too much time with sort of preliminaries because we have so much to talk about today. And I just want to again, like I really appreciate being here. One of my big problems in my practice, which we're helping to solve right here, is the problem of how do I get in front of clients before they're clients, like before the mistakes are made. And so I really, really so appreciate opportunities like what Blue Stoop is doing here by letting me speak to people, again, before problems become problems, hopefully. So let's just dive right in. Welcome to my little mini law school here. You are not going to be lawyers at the end of this hour, but hopefully you will be able to, as we like to say in law school, spot some issues when they come up and educate yourself so that you'll know when you need to talk to someone, when you need to have another set of eyes on something, and when you even maybe need to engage a lawyer. Surprisingly, a lot of what I do in my day job as a lawyer is help allocate risk. And you'll see how that plays out through the things we're going to be talking about today. We're talking about risk, we're talking about how to avoid it. And my sort of guiding principle in how we allocate risk is the risk belongs to the person who's in the best position to manage it or cover it or avoid it. And you'll see how that plays out. This is a little bit beyond the topic of the things we're going to be talking about today, which the things we're talking about today are in bold on this slide. But there are three legal mechanisms that I use in my practice. I don't do trial work. I am just a strictly business transactional lawyer. And the three things that we can do to help manage risk is form an entity. As you saw on that first slide, I practice law, but I practice through Sellei Law LLC, which helps keep my law practice within the confines of my little entity and helps avoid bleeding any liability, like if I screw up, into my personal life and into Gabrielle Sellei, the individual. We're not going to talk about forming an entity today. I just wanted you all to be aware of that as a way of shielding yourself from personal liability. Entering into really good written agreements, which we are definitely going to be talking about today, is another great way to manage risk. And as I just talked about, like sort of allocating risk among parties, that's what you do in a contract. And you'll see how that plays out. Another thing we're going to talk about much less, but that's a really important element of all of this is insurance. Talking to insurance people is surprisingly helpful because they do not bill you by the hour. They're trying to sell you a product, which is an insurance policy. So they will talk to you for free, but they have really great ideas and thoughts about how to manage and mitigate your risk. So that's just something to put in the back of your mind. The other thing we're going to be talking about a lot today is intellectual property. And there are lots of different kinds of intellectual property. You've heard these terms like copyright and trademark and trade secret and patent. And I will tell you, don't feel bad if you don't know the difference between all those things. I have worked with really good lawyers who use copyright and trademark interchangeably. They obviously don't practice in that area, but this is a technical area. We're going to be talking about mostly copyright because that is what we are mostly concerned about in our world. So we're going to start with contracts. We're going to start with some real basics. And the thing I love about contracts, I am obviously a total nerd about what I do, but the thing I love about contracts is it's not law like the law that's in the books. You have to do this or you have to do that, or these are the elements of this crime or whatever. It's whatever the two parties want. It's very creative. There is a structure and a format that you typically see in every contract, which we're going to talk about a little bit. But beyond that, it's really like, what do I want and what do you want? And how can we make that work together? So we're going to talk a little bit about negotiating and getting what you want. And you'll see that there's no magic to it. It's not like, some TV show where you see all these lawyers being all slick and like tricking each other and falling into each other's little verbal traps. It's not that at all. It's really just What do I want out of this relationship? What does the other person want? How can we bridge that? So some of the basic things that are in every contract, in fact, that you have to have in a contract to make it a real contract, is an actual meeting of the minds. We don't need to worry too, I mean, it is what it sounds like, but there's all kinds of variations on that in terms of like if one party is mistaken, if both parties are mistaken about underlying facts, but if everyone knows what the deal is and you have an actual agreement, it can be oral, it can be written, it can be expressed, it can be implied, it can be between two people or five people, it can be a lot of different things. You know what I'm going to say, probably. It really should be written and it really should be explicit. But that doesn't mean other kinds of contracts aren't enforceable. A contract is, by definition, if it's done properly, binding. And what does that mean? It means you have an obligation, the other party has an obligation, and if somebody screws up and doesn't come through, you can go to court and you can get that court to help you resolve that problem. Sometimes it's in the form of money, and sometimes it's in the form of the court saying, hey, you do the thing you said you were going to do. And the third piece that you need to have a legal contract, a binding contract, is consideration. And that can be, we usually think of consideration as money. And it's not just because lawyers like to have fancy words for things, it's because consideration, meaning the thing that you're giving in exchange for the thing that you're getting, can be money, but it can also, so in other words, it can be performing something you're not legally obligated to do, like writing a book or giving someone some money. It can also be agreeing not to do something that you otherwise are legally entitled to do, like not competing against someone or not disclosing someone's secrets. All of those things can serve as consideration and make an agreement binding. So that's just some like technical stuff I wanted to get out of the way so that we're all kind of on the same page here in terms of what an actual contract is. Um, and the reason we want a contract, and I know that it can be hard to ask for a contract if you feel like you're the person in the sort of worst bargaining position or you have less leverage. It's not because you don't trust the other side. It's not because, you think that they're going to rip you off. There's all these, I have clients who come to me a lot and say, I was worried about it. I don't want them to think I don't trust them. I really want to make this happen. I really want to get my art into that gallery. I really want to publish my whatever. And I want to just be really clear and that it's good to have a contract. It makes you look professional to ask for one. It is professional to have one. And there's so many reasons why we want to do that. Just think about, and you'll see the bottom of this slide, I talk about leverage. Think about like, and this, I say this to people who are not only in the arts and creative world, but also like people who are looking for jobs or looking for gigs. Like once someone has offered you a publishing agreement, a space in their gallery for a month, a job, a gig, a deal, in their mind, like if you think about it from the other person's perspective, they are already penciling you in. Like this person's going to be in my gallery in September. This book is going to be on my fall 2027 list. And when people do that, like when someone has a publishing company, for example, they're curating not just you and your thing, but their whole list and their whole catalog. And they've already pictured you in that spot. And they'll be really disappointed now if that doesn't work out. So it's like, you're not begging necessarily, or you shouldn't be thinking of it like, oh, I'm so grateful for this opportunity, because you are also giving them an opportunity to fill that spot that they have in their schedule. And beyond all of that, beyond the issues of leverage and all of that, contracts are really important. Like in the beginning of that relationship, when everyone is still really happy with each other and psyched, that's actually the time to have difficult conversations. That's actually the time to talk about money and all those things that are super uncomfortable, because you don't want to be having that discussion when there's a dispute or when there's tension or when there's stress or when you're under deadline or when something didn't go well or whatever. So having those conversations in the beginning of the relationship where everyone's in love with everybody, getting those issues out into the open, which is the only way they can ever get resolved, is if you put them out there and know about them. Contracts serve as a roadmap of a deal, and believe me, you will remember every single thing about this publishing deal, and you will get to fall of 2026 and you won't remember how much time you have to turn your proofs around. You won't remember anything. And a good contract is nothing more than just a roadmap of what everybody has agreed to. And they're super, super helpful. And as you get busier and you get more projects, it just gets even more confusing. And having like a good practice around contracts and who you've agreed to do what for is really important. And think of it also as not just when you're selling, putting your work out into the world, but when you are also helping other people do their work, or you have people helping you do your work, like you're having, working with a researcher, maybe you are working as a researcher, maybe you're contributing a chapter to something. All of these things have very, very different legal implications, both, for you and also for the work. So this is like just, it's boring and it's excruciating and it's basic bookkeeping, but it's really, really important. And so I think if you come at it from that standpoint, it just feels like, of course, we're going to have a contract. Like, of course, we need to record all of these details and who's doing what. In the literary world where we all are, these things are much more rote than in some other parts of the creative ecosystem that I work in. That every publishing house knows that they need to have a publishing agreement, for example. Um, I'm going to rip through this stuff really fast because this is like stuff that applies to every contract, but the who and the what and the where and the when and what happens when there's a breach. Um, these are just the sort of like the things that are in every contract, and they're very important. And you'll think some of this is so obvious, but like, believe it or not, I was looking at a contract today where like the name of the company was wrong. It was wrong. It was a different division of that company. And it was like we were in a contract with the wrong party. And that was a contract from 10 years ago when we were amending it. And one of my staff attorneys was like, Gabrielle, this isn't even the right party. I mean, it's crazy. It's been going on for, that's been there for years. And so like, it's not as obvious as it seems. But it is really important to get all this stuff right. As I talked about a few minutes ago, risk shifting is one of the main, and this is really what is so helpful and what is one of the most important elements of a contract is like, for example, warranties. That's you saying, my work is not infringing. My work is original. You will see these things over and over again in these kinds of contracts. Warranties are promises about the characteristics of the thing that's being transacted. And you know that term, warranties, guarantees, just from like everyday life. In a contract, they are basically promises that you make about the thing that you're transacting. Indemnities we'll get to in another slide. I don't want to waste time on that, but that's basically a promise. If you are wrong, if you make promises about your stuff and you happen to be wrong, you're on the hook for that. And you are indemnifying the other side for that. Insurance is, like I said before, you'll see it in every one of these contracts that we're going to be talking about. Assignment is very important in the publishing world because you can only transact what you have and you can only assign that or give that right to someone else if you've been given that right from someone else. And you'll see how that plays out as well. So again, these two slides we just talked about really, really quickly, these are just like basic stuff in every single contract in sort of the business arts world. Common agreements that I deal with in my practice and that you will see in your practice, literary agent agreements, of course. And by the way, that's a really interesting one because everything else here, publishing agreement, life story rights, book rights, all these things, which we'll talk about, are about transacting copyright, transacting intellectual property. With a literary agent, you're giving your literary agent a right, but you're giving them really the right to shop your book around. And they're going to want that to be exclusive, which is another important term that we'll talk about. But all the other agreements here are about someone having some intellectual property in a publishing agreement. You have a manuscript. A publisher is going to publish it. With regard to life story rights, I don't know if you're familiar with that term. If you are writing about a person, especially if they are not a public person who is a newsworthy person, but someone who is a private person, like probably every one of us in this room, it's not strictly necessary, but it's a really good idea, and your publisher will be really happy if you have secured the rights from that person to write about them, because it means they don't have to worry about a lawsuit. Another area that I do a lot of work in, which can get really complicated, are book books that are optioned for film and television, meaning there's a book out there in the world, someone in Hollywood likes it and would like to turn it into a movie or a television show or a series or a dramatic production or whatever, and they want to get an option from you for your book. And this is really interesting because unlike writing a book or writing a poem, putting together a movie is a really complicated thing because it involves many, many people, right? And so you can't just be like, oh, I'm going to buy your book from you and I'm going to turn it into a movie. You need to have some time to do that. So what an option does is it allows someone to say, hey, Gabrielle, I really like your book. I'd like to try to make a movie about it, but I'm going to need some time. I'm going to need a couple years to put it together. So I'm going to give you $10,000 and you're going to give me the exclusive right, meaning no one else can do this, to try to get a deal together for a movie based on your book. And I'm going to be like, okay, great, you go for it. And at the end of that 2 years, depending on how we've put together the option agreement, they might come back to me and say, I need a second option. I'm going to give you this time it's going to be more expensive. This time it's going to be $20,000, but I need another year. I'm very close. But I need some more time. Or they might come back to me after that initial option period and say, you know what? I got it. I got everything nailed down. I am now going to exercise my option and I'm going to actually buy the rights to the book from you. All of that, of course, is pre-negotiated, all the pricing and everything for that. I did a deal recently where my client my client is a filmmaker in that case, in that project, and he needed to get the rights to an autobiography that a scientist wrote about some important work that he did. But that autobiography was owned by the University of California Press. So we needed to actually get the rights from the publisher. We also needed to get the life rights from the author. So it was almost like there were two different things we needed there because we liked the narrative structure of the book and maybe wanted to think about doing something similar. We also needed to get the rights from the actual guy for his life story. And also we didn't want to get sued by the publisher. So even if we weren't going to use that narrative structure, we wanted to just get that out of the way. So you can see how this can get really complicated. The other really important thing to understand here is that initial sale of the book to, like, say, the publisher, or if you're going to publish it yourself, whatever platform you're using, it's really important how you structure that because that will have implications for all of the other arrangements that you might find yourself in with people that come forward in the future. I put contribution, ghostwriter, collaboration, and joint author agreements all on the same line because they're all very different things, but they all involve people working together on a single project. And again, you cannot tell your publisher in your publishing agreement that you have all the rights unless you have gotten all the rights from everybody who has contributed to your work. So again, this is all about like structuring things really carefully so that any talent that you're using, or sometimes you are the talent that somebody else is using, all gets sort of like consolidated into that agreement with the publisher. Similarly, translation agreements. Translation agreements are obviously critical and they are a whole separate right, a whole separate copyright, which we'll get to in a minute. And then another thing, of course, that is on the horizon in a big way these days are self-publishing agreements. I know that you can't negotiate them, but it is really important to know when you click that thing that what you're clicking on. And it is really important to understand what, like what you're doing, and you might need a lawyer to help navigate that. So these are all the different kinds of things that that I commonly see in my practice and that maybe you guys have seen too. So we kind of went through really quickly some of those typical provisions that are in every contract. But here's what I really want to talk about, which is the ones that are like how they manifest in literary agreements. The grant of rights, what we're actually giving here. Now, back in the day, publishing companies wanted to actually own the book. They wanted to take your copyright from you, and you still see that sometimes. But what I prefer for my author clients, of course, is to say, you have a license, you have a right to publish this book, but we're retaining the copyright. And the thing I love about contracts and intellectual property is you can slice and dice the world into geography, language, medium, length of time, all different kinds of, products that you can make out of a manuscript and so on. And so you have to be really careful with that and really understand. And then, it's hard to read these things sometimes because they're so wordy and dense, but it's really important to understand in that like big block of text about what rights you're actually giving your publisher, what exactly you're doing. You see in that third bullet there, I say beware of film and television rights. Everybody, now that the media universe is consolidated so much, everybody wants everything, right? So the same publisher is going to be like, I want to do your book. I also want to have television and film and dramatic rights and radio rights, and I want to have like everything. And I will say to the publisher, sometimes it's one of those big publishers, one of the big four, and you're like, okay, they probably actually do have the wherewithal to take this through a movie deal, but a lot of the smaller indie ones won't. And however, they'll sometimes say, well, look, Gabrielle, if we're publishing your client's book and it becomes like a runaway bestseller, and that's all because of us, and we found this talent and we promoted this talent, why shouldn't we have a piece of the film and television, upside? And that is not a bad argument. So we sometimes, we'll make a deal. Another thing that's really important in any kind of literary agreement, whether you're the buyer or the seller, is the timeline. Everyone gets hung up on the delivery. Everybody wants as much time as they can to like deliver their manuscript. We also get really into like how long the publisher has to publish, 18 months from whatever trigger date. But then there's a whole bunch of dates in between in terms of the comments and the editing and the copy editing and the line editing and all the different stages, and then the proofs. And somewhere in there, the manuscript gets accepted, which is like an actual legal term, at which time usually there's a payment due, if there's an advance. So all of that stuff, again, it's like really technical and really like, it's so easy to just gloss over it, but you really need to think about your project. You really need to think like, can I really do this? Or let's say you're teaching or you're traveling or you have a lot of stuff going on and they want you to turn like your edits around or your proof edits around in like 10 days, that might not be enough. So it's so easy to get like sucked into the form that someone gives you, but you really need to think about what you're looking at and whether it really works with your life. Another thing that's really important for writers is having creative control over your work. And I say last look because you want to be the last person who signs off on whatever it is before it goes to press. You want to make sure that if there's editing to be done, that certainly nothing is done that alters the meaning of what you're doing. Obviously, if it's a literary work, you don't want any of that kind of editing at all. But if it's a nonfiction kind of work, even there, you want to make sure that you have control over what's in there. And I will say the only book deal that I have ever lost, like that just died, was a nonfiction work where my client had like it was their life's work. It was their life's work was this subject matter. And the publisher did a lot of nonfiction and self-help and textbooks and that kind of thing. And they were treating my client's work like it was like an algebra textbook. They wanted to like just sort of have their way with it. And it was in a rare, insurmountable moment where I could, where my client had to just stand firm, and we ended up just walking away. It was really, really devastating. And she had obviously paid me money to do that. And one of the nicest things the client ever said to me in the wake of that was like, that was the best money I ever spent, because I was ready to sign it. I was so excited to put this work out there and I was ready to sign it. And, by reading it closely and realizing that they were reserving a lot of rights to make these changes, we realized we did not have a meeting of the minds in terms of what was going on there. Also, with respect to creative control, even though publishers are now absolutely loath to offer any kind of promotion of your book or marketing of your book in the agreement, they say they'll do it, but they won't commit to it in the agreement. You still want to make sure that anything that they do, you have an opportunity to look at. Everything from the author, jacket picture to the bio, to how they present your work, if they're going to consolidate your work or combine it with other works and issue it like in a, box set or an anthology. You want to have control over like even like who your work sits next to in some kind of like that kind of arrangement. So it's really important to reserve the right to approve all of those kinds of uses of your work. You might also be asked to waive your moral rights. And I want to talk about that for a second because that is a phrase that pops up a lot in these kinds of agreements and people don't really understand what it means. It's not really a thing in America, in American like intellectual property law. It's much bigger in Europe, but we still now, I see it everywhere now. And moral rights is really just two things. One is the protection of the integrity of the artist's work. And the other is the ability to disassociate from the work if it becomes so altered that you feel like you can't put your name on it anymore. So you can see how those two things kind of sit side by side. You might be asked to waive your moral rights. You certainly will be asked to waive your moral rights if you are, say, a contributor or a ghostwriter, right? And that makes sense, right? Because the quote unquote author, the person who is actually, the named author, is going to want to have the final say. Is going to want to have that last look and the creative control. So it's perfectly fine and normal to waive your moral rights in your work, even if you're going to be credited, right? You could be credited as a contributor and you still might be waiving your rights to what the final product looks like. You, on the other hand, might want to still make sure that you have the right to take your name off of it if it becomes so altered that you can't stand by it anymore. And that's the thing that can happen. So these are all really important issues in terms of the integrity of the work. And this comes up a lot. Moving on, and I am keeping track of time and we are like totally running out of time. So I'm going to try to speed it up. Advances in royalties. Everyone, of course, the first thing everyone is like, they flips to the page about the money. And I'm here to say this is really important, but I'm going to mostly talk about other things besides money. If you don't understand how advances and royalties work, it's something worth making sure you understand, but I don't want to take the time to get into it right now. I do want to talk about representations and warranties and covenants. We talked about this a minute ago. These are the promises you're making about your work or that someone is making to you if they are contributing to your work. And these are super important. Every publisher is going to want to ask you to basically represent to them or to guarantee to them that the work is yours, that you did not infringe anyone else's work in making it, it is original, or if it's not, if you used any third-party work in your work, that you obtained the rights to do that. They are also going to ask you to tell them that it is not defamatory. It doesn't invade anyone's rights of publicity if they're famous, or privacy if they're normal. The no harm done language is a good example of that is I'm putting a cookbook together. None of my recipes are going to kill you. Or let's say I'm putting together a book called How to Build a Bomb in Your Garage. And there'll be some kind of language in the agreement that says, if you follow this book correctly, no one's going to get hurt. That's going to be an important thing in some contexts, like medical, legal advice books, how-to books, that kind of thing. And as I mentioned a half an hour ago, restrictive covenants, the things that you agree not to do that you could otherwise do if you hadn't signed this agreement. You'll be asked not to compete against your own book, particularly if you're doing anything in the nonfiction realm. You're not going to do another book on the same topic for the same audience, say like, a book, another children's book about whatever, for let's say 2 years, because they want to have the opportunity to fully exploit and get your book out into the world. That same publisher might also want to get the rights to see your next book, and that's a good thing, usually. You want to be careful that sometimes they'll put some language in there that you agree to offer them the next book, and if they accept it, it will be on the same exact terms as in this contract here. And that I always say no to. Yes, you can have a look at the next book, but if I've now become a famous writer because of my current book, I'm not necessarily going to be willing to do the next one on the same terms. So again, it's really important to read what is in the agreement, because that's the kind of thing where you can be like, oh, that sounds reasonable. And it might not be. Confidentiality is usually just limited to the agreement itself. Like, don't tell anyone about the terms of this agreement. Don't tell anyone how much money you made. Don't tell anyone how much money I made. Usually pretty reasonable. Indemnity, which I hinted at before, is you've now signed all these representations and warranties. You've made all these promises about, the characteristics of your book, and someone comes forward and says, you plagiarized my work, or you didn't have the right to use this, whatever. Now your publisher wants to come to you and says, Gabrielle, you are on the hook for that, and I will be. So that's, again, we're allocating risk to the person who is the most in the position to fix it or, resolve it. And unfortunately, and this is again why all of that bookkeeping and note and record keeping is so important, including the contracts that you have from your people that are helping you, where you might need to get permission, to use the work or whatever. Like, you want to make sure that that is all ticked and tied down so that you can in turn transact it to the publisher. I also said before that how to get out of an agreement is super important. Most of the time, and I keep going back to like using a publishing agreement as an example. Publishing agreements, they always are going to ask that the term of the agreement, the duration of the agreement, be the length of the copyright, which we're going to talk about in a minute when we talk about copyright. And that's fair. As long as the work remains under copyright, they get to sell it. Unless they don't. Like, what if they just don't sell it? What if they just let it go out of print? What if they stop promoting it? What if it's just sitting there? It could be tied up for decades. So there's usually a provision in a publishing agreement that says, if this work goes out of print, the author can request that the contract be terminated and the work be returned to them. And that's called reversion. Anytime you enter into any agreement regarding intellectual property rights, like you're giving someone the right to your work, you have to absolutely make sure that when that contract comes to an end, the rights that you've granted revert back to you. The worst scenario in the world is the contract is over, the book is out of print, and guess what? The publisher still has the rights to those works. They never actually, so usually I put some language in there that when this contract terminates, the rights granted automatically revert. You don't want to have anyone have to do anything. You just want it to automatically revert as soon as this contract terminates. That's super important because you can't go ahead and do anything else with that work until you get your rights back. Okay. Mistakes in contracts are basically not having a contract, not reading your contract, not amending your contract when things change, and not reading your contract. You have a duty to read. That's like a thing that we like to say, the duty to read. And your eyes will glaze over, and that's where you need to get someone to help you. And I'm going to do a little commercial break here for Philadelphia Volunteer Lawyers for the Arts, which I've been a volunteer there for a million years. There are volunteer lawyers for the arts organizations everywhere, like in every major city. I think Georgia has one that's like statewide. They have some great websites with some great resources. They also, if you meet certain income guidelines and financial guidelines, will give you a free lawyer to do this for you. And it's just the best organization. So take advantage of that. And I also wanted to say a quick word about, we talked at the top about how contracts are not these big scary things, and they're really just about what the people want. Some of most publishers, literary agents, film studios, all those kinds of organizations, they're going to have form contracts. Do not be lulled into thinking you have to accept whatever is in those form contracts. They're going to look scary. They're going to have lots of words. They're going to have numbered paragraphs. And it's all negotiable. I mean, that's really what I want you to come away from this with. And if you're dealing with, for example, an agreement between you and a joint author, let's say you're collaborating with someone, you're not going to have a form agreement for that. You're going to have to draft your own agreement. And the way you do that is you just sit down, maybe just with an email, and you start with just bullet points. You don't go to a full-blown agreement until you've got, you kind of go back and forth by email, just like, hey, this is what I'm thinking. What are you thinking? Oh, I'm thinking this. Okay, cool. you get to some sort of point of agreement, maybe we do a little term sheet of something a little more formal, like a one-page document that says these two people agree on these things. By the time you get to the actual agreement, it should pretty much write itself, because by this point, you've talked about it, like just like how normal people talk. And you've gotten some things on paper and you've gotten some bullet points and you've thought through some of these issues that we've just been talking about for 25 minutes. And now the drafting the agreement should be the easy part, right? Because you've already done all the things. You've already had the conversations. So that's really what I want you to come away with. These are just malleable, shiftable. It's really what you want. And sometimes you'll be given a form because you'll be dealing with some big organization that's just as malleable as one that you would start with. Okay, let's move on to copyright. And I am sorry, this is like a fire hose of information. But again, all we're trying to do here is so that in the future, if you come across any of these issues, you'll be like, oh my God, that lawyer, she talked about this. I should read this. Copyright, there's so much confusion about copyright. This is the fun part of our evening here. Copyright is so simple, and then it gets really complicated. But at its base, copyright is just the exclusive right to these 5 things: to reproduce, make derivative works from, distribute, perform, and display your creative expression for a limited time. This is a right that comes from like the government, from the Copyright Office, from the Constitution. And so it's not like it's not like contracts, like stuff that we make ourselves. This is like actual law that is presented, propounded on us. The key thing here is that it is this bundle of rights. That term creative expression has to exist in tangible form. I can't say to you, I have this great idea for a movie. Let's do a screenplay about blah, blah, blah. And then you go and do a screenplay about that thing. And I'm like, wait a minute, that was my idea. Too bad. It did not exist in tangible form. If I send you an email and I say, hey, I have this great idea for a screenplay, blah, 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 and it's in an email, that's different. And it's crazy that that's different, but that is really the dividing line here. You cannot have a copyright in an idea. The flip side of that is a copyright exists. It comes into existence the second that work exists in tangible form. So you don't need to register it with the Copyright Office. You don't need to put that little C in the circle, although we're going to talk about why you should. You don't need to publish it. You don't need to mail it to yourself. All these like sort of things that everyone says. It exists. I wrote a poem yesterday. I have a copyright in that poem. So that's the main thing. I mean, that's really the thing about copyright. That's everything you need to know right there. And then, of course, it gets super complicated. I did say creative expression. And a work, in order to be copyrighted, does have to have a minimal amount of creativity. We don't need to worry about that here because we're writers, right? But, for example, it would be helpful for you to know this because you might be using other works and you want to know, can I use this or not? Creative expression, like if I were to say, I'm going to put together a list of all the birds that live in Pennsylvania. That's not creative expression. That's a list of facts. The phone book is a list of facts. There is no creativity in that, and therefore, if you find a list of birds in Pennsylvania, you can use that. If it's a list of birds in Pennsylvania that's illustrated, that's different. That has creativity in it. So, but again, it can be just a bare, or it could be a list of birds, but it's in some like fancy, nice script or font that somebody made. That's creativity. But just the list itself is not subject to copyright. And then there's other things. We're not going to talk about trademark, but there's certain things that are small little logos, slogans, that kind of thing. That's trademark. That's for another day. Duration. This is not so important for us. Anything we create today lasts for our life plus 70 years. So even after we're gone, our family gets to continue, or our heirs get to continue to exploit our work. And you know that this happens because you see, the estate of blah, 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 claiming rights in music and all kinds of things. The reason this is important is because if the copyright has expired on something, it is now in the public domain. And we're going to talk about that in a sec. But you can use it. You can freely use, anything you want. Jane Eyre. I mean, you can use anything you want that is out of copyright protection. So And because copyright, like I said, it is law that people write, it changes all the time. And it's really annoying if you're trying to figure out if something from like, I don't know, whatever, 1927 is in the public domain. You got to figure out like when was it created and what was the law at the time and what is the law now. Don't try that at home. Just like ask a lawyer. But the current Life Plus 70 years has been around for a while. So we're good. Like all of us who are writing today, that's the deal for us. Um, there, I have this theory, this conspiracy theory that the law has invented a lot of terms that sound like they mean something, but mean something completely different, just to help lawyers make a living. And one of them is fair use, one of them is public domain, there's a few others, but fair use is like so confusing. It's an exception. This is the important thing. It is an exception to the copyright law, the Copyright Act that we just talked about, which gives you the exclusive use of those for those 5 purposes. Fair use allows you to use works that are protected by copyright in certain instances like criticism, comment, news reporting, teaching, parody, and research. And think about it. How can you do a book review if you can't excerpt a little bit of that book? Or how can you review a gallery exhibit, if you can't show like one of the works? It's so much more meaningful to actually share some of it. So the problem with fair use, as I tell my clients, is like the way that you prove whether you actually were correct in assessing that this was accepted under fair use is you have to have litigation. Like there's just no hard and fast rule of like when you've stepped over the line. So the result for like a lawyer who's advising a client is we tend to get very conservative. We tend to say, just get permission, unless it's clear, unless it's obvious, unless you're a news organization doing news, or you're a book reviewer doing a book review. Like, those are like the easy ones. But the rest of the time, I'm like, just get permission. And I say just like it's easy, and sometimes it's really not. There are factors that courts look at when they are determining whether something is fair use. That last bullet is really, to me, the second to last bullet is, it does have something to do with the amount of the work that you're using, but if you're just using a tiny bit, but it's the heart of the work, like the riff that everybody knows, or the line from the poem that everybody knows, that might be considered not fair use. And then the last bullet is what effect that use will have on the market or the value of the work that you're using. So like, the copyright is trying to protect creators from, getting ripped off. So if what you do kind of like, makes the market for the underlying work that you're using obsolete, the courts are not going to like that. So it's really hard to advise on, as you can tell. This is very like fuzzy stuff. But fair use doesn't just mean like it's fair. It actually means something in the law. Another one of those that I just talked about for a minute is public domain. What does that mean? Works that are in the public domain are the ones that have either come out of copyright, so they're the Life Plus 70 years, that's now over, and you can use it. Like any work by Shakespeare, any work by Mozart, like those things are all in the public domain. So that's one example. And another example that a lot of people don't know about, which is amazing, and this, could change tomorrow, but as of right now, works created by the United States government. And this is a treasure trove of stuff when you think about like the maps, National Park Service guides, photographs, reports, like the graphics. That's a ton of stuff. And if the federal government makes it, they made it with our money and it's ours and you can use it. So if you're looking for, I don't know, an illustration of something or whatever, that's a good source. And also works that are expressly indicated as being in the public domain. And you might be familiar with Creative Commons and copyleft and all of these other kinds of like schemes and regimes that, where people deliberately put work into the public domain because they believe that, that's like the right thing to do. And that's another place to look. Again, you got to be super careful. And we just talked about those representations and warranties you're going to make to your publisher. They're going to want to know, like if you're relying on something that's in Creative Commons, they're probably going to want to know about that because they're going to want to like check and make sure. Like a lot of those common licenses, they require that the thing that you make with that material also be available to everybody, right? So that's their whole ethos is like, we think this material should be available to everybody. But we also, if you're going to use it, you need to make your thing available to everybody too. Most publishers are going to be like, no, thank you. Julian, did you have a thought, or are you cutting me off for time?
I want to mention there's about 10 questions in the chat, and I'm sure there are more. I don't know how you want to handle it, but
Okay.
I thought I would flag that.
Okay, we're almost done. We're almost done. I'm going to rip through this. Joint authorship. Let me just say, joint authorship, you got to have an agreement. That's all I'm going to say about it. Because the default rule is if you and someone else work on something together and there's no agreement, you each can do whatever you want with that thing. Meaning, if you decide you want to like write that poem and you're going to sell it to a tobacco company or gun company or just pick your bad guy for their advertising, your writing partner can do nothing about that. The only thing they're owed is 50% of the proceeds. So joint authorship, you got to have an agreement. You just have to. Too scary not to. Copyright notice, you should use it. It's three things. It's the copyright symbol or the C in the circle, the year of publication, and the copyright owner's name. And I always add all rights reserved. Copyright registration, you should do it. This is where like volunteer lawyers for the arts organization can be really helpful. And you actually need to register if you're ever going to sue someone for infringement. We're going to skip that. Freelancers versus employees, or that's another really important thing. When you are a freelancer or when you engage a freelancer to help you, an independent contractor, someone who is not a W-2 employee, they own their work. You own your work as a freelancer unless you transact it in writing to somebody else. So if someone helps you and someone's writing something for you, you have to get an assignment of the copyright of what they've done so that you can then use it in your work that you are publishing. That's really important. Things that people ask about, time permitting. Well, instead of doing that, why don't we just go right to things that people are asking? And we have like a few minutes. And Julian, feel free to referee this because I can't even see what the questions are.
Oh, we could go rapid fire style.
We'll just do like ask me anything and rapid fire.
Okay. Rapid fire one. I'm just going to summarize these, so my apologies if I get anyone's question summarized wrong. Number one, where can I find contract templates for freelance writing?
They are literally everywhere, including Google, but I will just caution, make sure that it's in the state you want to be in, and that reading every word and understanding it. They're easy to find. I like books. I mean, I like books that have like an online component because they're usually by a lawyer. And I have a whole bunch of them myself, so I prefer to use ones that are drafted by a lawyer. And usually if you buy a book, like, agreements for writers, it'll come with, a downloadable something or other. And that's would always be my preference.
This next one's a little complex, but basically they're asking, is a video release a contract, and would it include the ability to for the event holder to alter the writer's work or image?
I would not rely on a video. I mean, unless we're talking about something that's in a video medium, like someone saying, like, if I were to say right here on this thing that's being recorded, like, I agree to be recorded, that's just for this, but that's not going to indicate for what purpose you can use the recording. It's not going to indicate like how, you're not going to sit there and recite all those terms, right? If I understand the question correctly, it's just never going to have, you're not going to sit there and like do all of that on a recording if I'm not missing the point here.
I might also be missing the
Okay.
point. So my apologies sincerely.
My contact information is on the screen right now. And I always say, like, if you sat through an hour of this, you deserve a free phone call or text me or whatever.
It's very generous. All right. You ready for another one?
Yes.
All right. This person is writing a fictional novel that uses a famous person from history from hundreds of years ago. So it's not really possible to get like a release. Is there any legal risk there?
No, there's no risk from that person or even their estate, that kind of thing. What you do need to be careful about is you're generally going to be researching, like you can't interview them, but you'll be researching and you'll be using secondary sources. And to the extent you're doing that, as opposed to their own writings, which would be out of copyright and in the public domain, You need to be careful about how you're citing or using secondary sources, people that have, in other words, people that have already written about this famous person. The famous person themselves and their own writings is fine. People that wrote about them contemporaneously is probably also in the public domain for the same reason. Something that someone wrote about them 10 years ago is going to be subject to copyright.
This one, along a similar line of thought, they are writing a fictional novel. There's some science in it. They researched the topic online and incorporated what they learned online into the character's dialogue. Is that plagiarism?
Um, Again, there's no copyright in facts. So if you extracted the facts from wherever you extracted them from, and then you put it into completely novel, made up dialogue, I think that would be fine. But again, this kind of question is so fact specific. You would probably need to, and I should probably say, like with my big lawyerly caveat, that all of these situations are so fact specific that they really need like one-on-one whatever. But I hope I'm just sort of sharing like a pattern or way of thinking about this kind of thing.
Useful caveat. All right, this next one is relevant to AI generated work. Obviously, a lot of agents and publishing entities don't want anything to do with it. So this person is like wants to know sort of your general thoughts about that, and also more specifically, sort of the boundaries of that. So would something as innocuous as autocorrect be considered AI in that case?
Yeah, that's a great question and a great point because AI is like, I mean, there's like research software, like legal research software that will, give you a little squib about what a case is. And that's AI right there, right? I mean, there's like AI has been around for a long time, but when people use it now and when I see it in agreements now, unfortunately, it's usually like someone wanting permission to use my client's work to feed it into their, large language training module. And we don't like that. In terms of using it, you are going to have to make those representations and warranties that your work is non-infringing and that it is original, that you did it. So I don't see how you can make that representation that the work is original and created only by you. Um, unless if you're using AI and then there's that caveat or that you got the rights to use it. And I guess that's the thing. And like, what rights do you have to use that AI? Do you have to then be able to transact them to your publisher so that your publisher can publish the work? I think it gets really hairy and complicated. Again, it needs to be looked at like sort of on a more case by case basis. But keep in mind, if you're using AI, you have a really hard time claiming that that's your original work. I think that's really the problem with it.
It's a hairy, a hairy zone. All right, so this question is sort of about memoir writing and privacy issues. They wanted to know what the privacy of non-public people encompasses. So like if the names are changed or they, don't include last names, would that cover it?
Well, the problem is if you're saying that it's a memoir and you're changing the names of everyone in your family, but it's still published by you, people are gonna, of course, be like, oh, well, okay, so she called her mom Catherine instead of Sarah, but that's her mom, right? So that's a problem. I mean, that's a problem for the private people who are involved, and that can be very tricky. That can be a very tricky area. And that's why people wait till everyone's dead, or they get permission, or they just go, or they just fictionalize everything. I mean, there's ways to do this, but I mentioned rights of privacy and rights of publicity, and people having their, people having their dirty laundry, who are private people, dragged out into the world and published. They may have a right of privacy claim. And I've also discovered doing some research on a project that there's like at least one state where I think like it kind of lasts forever. And unfortunately, because of the internet and the way publishing works, the one state is going to be like the lowest common denominator. It's going to like prevent you from doing anything anywhere because you can't just be like, oh, I'm not going to sell that book in Connecticut, So this is really I want to say it's a problem. It's a problem for people who are writing memoir or things about real people that are not flattering.
My apologies, Susan. I'm gonna skip over a couple of your other questions so I can get to Kathy's. Kathy's wondering, what about paraphrasing instead of quoting? How does that impact?
Um, it depends. Because if it's a work of nonfiction, as it sounds like it probably is, and if, you could use footnotes or endnotes and you can, um, I mean, copyright, it's almost impossible to answer something like that in the abstract, but you would certainly at the very least want to give ample credit. And sometimes you even, publish or add a link to the thing that you are paraphrasing so that it's really clear. I mean, the more you can do to sort of, to clarify what you're doing, the better. But you know, and you can disclose that you're paraphrasing too. It really depends on the nature of the work that we're talking about.
A couple other questions, but I feel like we might be up against the clock here. So I'll let you wrap up. And thanks for answering all those.
Yeah, I mean, I know this is like a lot and it's very technical and it's very dense, which is why lawyers exist, really, because this is what we do. But like I said in the beginning, I just want people to have to have this in mind when you are approached about an agreement, and certainly when you're thinking about copyright and when you're thinking about what you're writing and what you're using of other people's work and what other people are using of your work. So I really appreciate everyone's attention and the really good questions. And Julian, thank you for having me.
Yeah, thank you for being here. I know I learned a lot, and I can tell everyone else did too. So, like I said before, this is recorded, so we'll put this up on YouTube after you can rewatch and soak up more of this good information. I'm going to post some links in the chat. Check those out when you have a sec. The first one is a link to a feedback survey, so you can let Gabrielle know how helpful this session was, or let us know what kind of other Thursdays on the Stoop sessions might be useful to you in the future. There's a link to spring classes. They are open for enrollment now. We've got financial aid, we got payment plans. We'd love to see you in the classroom, either online or in person. Upcoming events, more workshops like this. Instead of this type of thing next week, we're actually doing a Q&A session and meet and greet with some of the, I don't know what semester this is, spring teachers. And you can also ask me questions about how our payment plans work and all that kind of stuff. We're just going to be available to answer your questions. And then we'll resume this type of workshop the following week. It'll be 2 weeks from today, it'll be poetry as pleasure. I think it'll be like sexual liberation type stuff. And then there's a link for the newsletter so you can stay on top of all of it. And of course, if you want to support more free programs like this one, you can go to bluestoop.org/donate. Link is in the chat. And if you pitch in any amount, literally any amount, between now and February 6th, you'll get an invite to a very exclusive, fancy virtual event with local writers or writers of books with local ties that'll be taking place over Zoom. It's going to be really cool, and you're going to feel very special for getting invited because you pitched in 25 cents or a dollar or $10, whatever your budget allows for. Anyway, we'd love to see you there. Thank you again for taking time out of your busy schedule to be here, and thank you, Gabrielle, for making it happen. Enjoy the rest
Yeah.
of your day, everyone.
Awesome. Bye, everybody.